There are two different views of the Constitution. Party A holds view 1A, and that is the living Constitution view. That is this. It's the belief that the Constitution is a living document that changes meaning according to the changes of society. And judges should tell us just how the Constitution is changing. And therefore, judges should have the power to decide all the major issues facing the nation. 4 justices on the Supreme Court hold this view: Ginsburg, Breyer, Sotomayor, and Kagan. The opposite view, Party B view, is the Constitution has a fixed meaning. What is that? It's the original public meaning. That is, it's what the words meant when the Constitution was adopted. Judges should interpret the Constitution, not change it. Well, then how should the big issues in the country be decided? Freedom of religion, abortion, marriage, definition of marriage, and other issues. How should they be decided? Well, the way the constitutional writers set up those issues to be decided by the elected representatives of the people in the U.S. Congress and the state legislature voting and deciding, because they are most accountable to the people. It shouldn't be decided by the Supreme Court. And why is that important? It's because our whole nation is at stake. The fixed meaning of the Constitution is our foundational protection against the tendency of governments to usurp more and more power. 4 justices currently on the Supreme Court hold this view, this original meaning view: Roberts, Scalia, Thomas, and Alito. 4 on one side, 4 on the other side. That leaves 1 justice in the middle, Justice Anthony Kennedy. And the way he decides, whether he sides with the conservatives or the liberals, makes the difference in how many, many, many issues are decided. In fact, you voted on Proposition 8 here in California. The arguments are gearing up to go to the Supreme Court, whether that will stand or not, whether the Supreme Court will overrule your choice and say that same-sex marriage is the law of the land. The lawyers on both sides have primarily written their arguments to appeal to Justice Kennedy because they're quite sure that he by himself will make the decision. This is not the form of government that our founders set up for us to have, where one man, never elected by anybody, never accountable to the will of the people, and having life tenure, decides the major issues of the nation. It's not the kind of government that we were given in God's good providence when the Constitution was written. Now, see, when our founding fathers set up the government of the United States, they had to decide, to whom will we entrust the greatest power in the nation? They decided they wouldn't entrust the greatest power to the president, and they wouldn't entrust the greatest power to the Congress, and they wouldn't entrust the greatest power to the Supreme Court, and they wouldn't even entrust the greatest power to the majority of the American people. Our founding fathers decided, instead of entrusting the greatest power to any person, they would entrust the greatest power to a document, the Constitution, that would be above the Congress, above the president, above the courts, and above the people. Now, you could say, yes, the people can amend it. The people and the court and the Congress and the states can amend the Constitution. Yes, they can. Very difficult process. They can do it. But unless the Constitution is amended, the Constitution is the supreme authority in the land, and everybody else has to be subject to it. As long as that principle is maintained, the Constitution has all sorts of protections that protect us from what people fled from England to get away from, and that was a government that took more and more and more power, as governments tend to do, and the government that became a tyranny. And they set up the Constitution with the Bill of Rights and many other protections, the separation of powers and other things that would protect the people against the government. As long as that is protected, our system of government and our nation as we know it stays in place. But under the living Constitution view, view A, the judges can come along and they can say, oh, we found a new meaning here, and it really isn't what it meant originally, but they make up a new meaning and they say, that's our interpretation. Now let me tell you how that goes. If you're driving If you're driving 60 miles an hour in a 30-mile zone and you get stopped and you say to the officer, well, I interpreted 30 to mean 60. He would say, good luck, buddy. You can't just change the meaning of words to your own liking. But that's what's happening. Let me show you a couple of examples. Let's see if we could get the PowerPoint up here. I think I need to do this. th Amendment. The Civil War ended in 1865. 1868, the 14th Amendment was finalized and approved. It was just after the Civil War, and the purpose was to be sure that freed slaves had the full rights of citizenship. So any person, all persons born or naturalized in the United States are citizens. And it went on and said, nor shall any state deprive any person of life, liberty, or property without due process of law. There were laws prohibiting or restricting abortion in about 37 states at the time the 14th Amendment was adopted. I don't think one human being in the whole United States thought that the meaning of those words, those yellow words, had anything to do with abortion or guaranteed a right to abortion. That wasn't what the words meant. But in 1973, the Supreme Court looked and looked and looked at those yellow words, and they said, behold, these words guarantee any woman can take the life of her unborn baby at any point in pregnancy. You say, I don't quite see that in those yellow words. And you're right. It's not there. But the Supreme Court said it was there. And so for all practical purposes, the meaning is there for the whole country. And all 50 states, all of their laws that had anything to do with restricting or prohibiting abortion in all 50 states, in 1 second, when that decree was issued, the laws were wiped out, because the Constitution is the supreme law of the land. And by changing the meaning of the Constitution and calling it an interpretation, the judges figured out that they could decide that issue for us. And there is nothing you can do about it. Nothing. Congress can pass laws against abortion. They'll overrule it. They'll say it's unconstitutional. States can pass laws against abortion. They'll say it's unconstitutional. This is the supreme authority in our country. If you get hold of this and you can tamper with it at your own will, all of a sudden you rule the whole country. You see the problem?